To meet the legal definition of an SMSF, all fund members must generally be trustees of the fund or directors of a company that is trustee, and vice versa. Sometimes this is not practical or even possible. This may be because director trustees spend such a long time living overseas that their continued trusteeship puts the SMSF's residency status in doubt. It may also be because the trustee has lost mental capacity. An enduring power of attorney granted by the member, the grantor, to a trusted person, the attorney, is a common solution, but what does this entail? Once an enduring power of attorney is activated, it is not a matter of the attorney acting on behalf of the member, they act instead of the member. That means they have all the rights and responsibilities, including liability for penalties. Given the onerous administrative penalty regime that applies to individual trustee SMSFs, it might be considered unwise to accept the appointment unless the SMSF has a corporate trustee. Advice should be sought. The attorney can make investment decisions and, subject to the deed and/or provisions of the enduring power of attorney, may even be able to alter binding death benefit nominations and decide on benefit payments in certain circumstances. Clearly, both the choice of the attorney and the decision by the attorney to accept the appointment are significant considerations. An enduring power of attorney cannot be granted once mental capacity has been lost. It must have been granted beforehand. Also, as enduring powers of attorney are subject to state legislation, their continued validity must be checked if the grantor becomes a resident of another state. Remember that an enduring power of attorney ceases on death. It can also be revoked by the grantor at any time, though this is a complex issue if the grantor's then mental capacity is in doubt. It's common for spouses to be the enduring power of attorneys for each other, but is this appropriate? In blended family situations, it may not be. It's also common for an overseas residency issue to be dealt with by both individuals in a couple, providing enduring powers of attorney to trusted Australian residents, but that's not always necessary. Generally, only half the trustees need to be Australian residents. Voting powers and influence are also relevant and need to be considered. Professional advice should be sought. The activation of an enduring power of attorney and trustee director replacement requires some attention. The process differs depending on whether the fund has corporate or individual trustees, but is simplified if the attorney is already a co-trustee director, usually by virtue of existing fund membership. For a corporate trustee, the director must resign and the new director appointed. This process is enabled by the enduring power of attorney. It is not authorised by it. The director replacement must be in accordance with the company's constitution. Note that we are considering enduring powers of attorney, not wills, but the executor of a will has a similar issue and can't be appointed simply because they are the will's executor if the company's constitution does not facilitate this. This could pose a significant problem in a hostile beneficiary situation, as may occur in a blended family, unless appropriate arrangements have been made prior. A change of director for a corporate trustee does not require any change to the names in which the SMSF's assets are owned or to the SMSF's trust deed. For an individual trustee, the resignation and appointment process is set down in the deed, but both the deed and the names in which all the investments are held must be changed to reflect the change in trustees. This can be a significant task and, as it's required in any case, presents an opportunity to change to a corporate trustee as part of the appointment consideration. This is particularly relevant when you consider that any subsequent change will require the same process, which, if a corporate trustee is appointed at this time, will make matters so much easier. Often, the attorney is also the executor of the member's will. As it is easier to be appointed as a trustee director prior to the member's death, a useful consideration would be to make the appointment under the enduring power of attorney beforehand. Though it's revoked on death, the trustee appointment would still be allowable if the attorney now becomes the member's legal personal representative under their will, thus streamlining the process. The attorney is compelled to act in the best interest of the grantor. This may not always be practical or useful in the broader sense. For the attorney to change binding death benefit nominations and/or withdraw member benefits, including just prior to the member's death, the enduring power of attorney must contain appropriate conflict provisions. These can be tailored and need to be carefully considered, particularly in blended family situations. Note that they will generally not be acted upon by other types of superannuation funds, so this flexibility is peculiar to SMSFs. Lastly, appointing an enduring power of attorney is no solution for bankruptcy. The bankrupt member will still need to make alternative superannuation arrangements outside of an SMSF. It is advisable for all director trustees to have an enduring power of attorney as part of their standard documentation, as it may be required unexpectedly. Its specific detail and continued effectiveness should be considered along with the member's will and binding death benefit nominations. Advice should be sought. We hope you have found this information useful. For further clarification, you should speak with your financial advisor.